Good afternoon, this is Sean Golding with Golding & Golding, here to discuss a very common issue we come across. There's a lot of misinformation out there, and it's the whole idea of if a taxpayer doesn't know about the FBAR, does that automatically mean that they don't qualify for a potential penalty mitigation or penalty waiver? Okay, short answer is there's always where there's a will, there's a way. Totally depends on the facts and circumstances. Why don't we take a look? Baseline perspective, the FBAR is FinCEN Form 114, Foreign Bank and Financial Account Reporting if a U.S. person. We're just focused on individuals, but it involves other U.S. persons as well. Person doesn't just mean individual. But if a U.S. citizen, legal permanent resident, lawful permanent resident, or foreign national who meets the substantial presence test has more than $10,000 in annual aggregate total in foreign financial accounts, bank accounts, foreign life insurance, pension, things of that nature, more than $10,000 in any given day, then they're required to file the FBAR, whether they have ownership, joint ownership, or signature authority. If a person doesn't file it timely, files it inaccurately, never files it at all, they may become subject to FBAR penalties. Okay? Examiners have discretion when it comes to the penalties. Oftentimes what will happen is the taxpayer gets dinged with the maximum amount of the penalty, $10,000 either per account per year or per year, The $10,000 adjusts for inflation, so it's closer to $13,500, $14,000 now. Right, if you got hit with willful penalties, you could try to bring it down to non-willfulness, or you can show reasonable cause and not willful neglect to try to reduce or eliminate the penalties. But what about the defense that the taxpayer just didn't know about the FBAR? Okay, never heard of it, didn't know that there was something they had to do, or maybe they possibly heard about it but didn't know they had to file it because of some information they received. Okay, let's go through a simple but common example. Peter is new to the United States. He's a lawful permanent resident. The taxes seem way too hard. In his country, you don't really have to do anything. In most countries, it takes 5 or 10 minutes. It's not a big deal. It's not like the US at all, okay? So he goes online, does his Google research, and he finds a CPA. CPA says he's got experience in international tax. So step one, we're not talking about a CPA who represents that he has no experience in international tax and FBAR. If a CPA says, hey, Peter, bro, I've got no experience in this stuff, then Peter can't really rely on him. But this guy says he knows what he's talking about, and so Peter feels good. The CPA gives the taxpayer an organizer with a whole bunch of questions in there and information and what Peter needs to provide. Taxpayer doesn't have bank accounts, okay? But taxpayer has pension accounts, right? He's in a country where there's multiple pensions, there's multiple accounts. He's lived in 3 different countries, actually, so he's got pensions in 3 different countries, close to $500,000. He talks to the CPA, and the CPA says foreign pensions are not necessarily to be reported, okay? And Peter goes, why? And he goes, oh, are you getting distributions from yet? He goes, no. He goes, it's like a 401k, and you don't have to deal with anything with it yet. Don't worry about it. When you start getting distributions down the line, then, bring it back up to me, and we'll figure it out. And, of course, Peter takes this advice, and he gets penalized. Now, let's look at this for a minute. The CPA represents that the CPA knows what he's doing with international tax. The CPA's heard of reporting things like the FBAR 8938. Peter gives the CPA all of his account information, so he's not hiding anything. Peter asks the CPA, who represents that he does international tax, and he's a certified public accountant, right? So Peter is able to rely on him, okay? And he tells Peter, you don't have to do it, okay? Even dealing with the IRS and how difficult they can be, there is not much more Peter could do to be reasonable, right? He had just moved to the United States. He just got his lawful permanent resident status. He hired a CPA. He gave the CPA the information. The CPA told him that he didn't need to file it, gave him a reason why, and so Peter accepted it. Is that sufficient to avoid penalties? And possibly, okay? And so the moral of the story is, just because a taxpayer doesn't know about the FBAR or doesn't know they have to report something on the FBAR, in and of itself does not mean that that is insufficient to prove reasonable cause. Okay? There's a bunch of information online. It's a bunch of fear-mongering letting you know if you didn't know about it, there's no way on this God's green earth that you could ever fight the FBAR penalty. That's not true. It's a totality of the circumstance, okay? If you act with due diligence, your actions are reasonable based on the totality of the circumstance. The fact that you didn't know about the FBAR and didn't know that a specific account goes on the FBAR and you relied on a professional, a licensed professional who represents to you that they know what they're doing may be sufficient. If you're out of compliance for prior years, you may want to consider doing one of the amnesty programs. They're great. They help you get into compliance safely. There's a voluntary disclosure program if you're willful or just can't certify under penalty of perjury that you're non-willful. There's the streamlined filing compliance procedures. Domestic and foreign has nothing to do with the location of the accounts, but rather location of the taxpayer. Reasonable cause and delinquency procedures. We have tons of free information on our main websites and our sub-websites. You can always reach out and schedule a reduced fee initial consultation if you think it's appropriate. Again, my name is Sean Golding with Golding & Golding. Thank you for your time. Enjoy the rest of your day.